Welcome to the program. I'm honored and thrilled to be joined by Jonathan Blotmacher and Ed Morrow, and I think it should be a very interesting program. And I'm looking forward to learning a lot from these two sage estate planners about really what could be one of the hottest topics. Lots of people are doing lots of SLATs, and how do you provide access, and what are the issues? And I think that we'll get some interesting theoretical discussions, but a lot of practical advice. So stick with us. Let me dispense with a few quick housekeeping points. These are for educational purposes only, this and all the video clips on the websites. A couple of pointers. You can download the handout of the PowerPoint on the web console. Should you miss it within a week of the program, it'll be posted to Schenkman Law website along with the recording, the ILS website, and the PEAKS website as well. So lots of places that you can get it. We do not give CLE or CPE credits, but we do send out a certificate of attendance. We can't control or address anything on the certificate if for some reason it doesn't come or doesn't come correctly. There's nothing, unfortunately, that we can do. If you have questions, the speaker emails are at the end of the PowerPoint. Please email us rather than posting it in the Q&A on the webinar tab. That's important. Vanessa, all yours.
All right, thank you, Marty. I'm Vanessa Kanega. I'm the CEO of Interactive Legal. We're, as always, happy to sponsor a webinar featuring Marty and Jonathan, and in this case, Ed Morrow, a distinguished guest. So can't wait to hear the information they're going to provide, and glad to be a sponsor. As Marty alluded to, you will find other webinars and other educational materials and articles on the Interactive Legal website at interactivelegal.com. And of course, we'd love to have you request a demo of our product if you haven't yet seen it. You're also welcome to call the number listed there or email sales@interactivelegal.com for more information. Thanks so much.
Vanessa, you're being bashful. You should also tell everyone that whether they want to do non-reciprocal SLATs or SPATs or DAPs or hybrid DAPs, they can do all of that in an interactive. A lot of what we're going to discuss will be available. Yes.
So, yes, we have a lot of the techniques that I have no doubt you are all going to cover today. So any of us would be glad to talk through that with you. If you're interested, please reach out.
Okay, thank you. Nicole.
Yes, and then PEAK can administer those trusts after ILS puts them together. So welcome everyone, and thank you for attending today's webinar. My name is Nicole King, and I'm a fiduciary officer here at PEAK Trust. And as always, we are pleased and honored to be able to sponsor today's presentation. PEAK Trust Company is offers a full spectrum of trustee services, specializing in the administration of trusts pursuant to Alaska, Nevada, and Delaware law. We provide a highly customized delivery process tailored to your client's specific needs, providing everything you want and need, but only what you want. So I invite you to visit our website at www.peaktrust. If you should have any questions, feel free to contact me or any member on the team. So enjoy the webinar.
And as an additional plug for institutional trustees generally, if you have not read the Levine split dollar case, you should absolutely read it. The court waxes and wanes on how positive it was that the taxpayers in that case used an independent institutional trustee. And that is certainly something that can help, I think, improve your planning. And let me just off target from the PowerPoint. Jonathan and Ed, everyone's always talking lately about the reciprocal trust doctrine. Until a few years ago, nobody talked too much about it. It kind of started in 2012. But if you have an attack on, and stay with us, Nicole, just for one more second. If you have an attack on a reciprocal trust, that the two SLATs are too closely aligned, they're too similar, that they're reciprocal. My understanding is if I created a trust for my wife, it's as if she created it for herself. They uncross them. The trust she created for me is as if I created it for myself. So I guess the question is, if you have these trusts, not in New York or California or New Jersey, that don't accept domestic asset protection or self-settled trusts, but if you form these trusts in Nevada, Delaware, South Dakota, Alaska, in DAP jurisdictions, if those trusts are uncrossed, can you not end up with just two self-settled trusts? So if you have an independent institution in Alaska, I believe you need a solvency affidavit. If you take the few extra steps, are you not protected? Thoughts,
Well,
comments?
Marty, that's absolutely true, and I think we'll emphasize that again, that even though we're going to discuss some techniques where you can do planning theoretically not in a self-settled trust jurisdiction, you could do it in New York or California, two of the worst places to be a debtor. Using a concept which I developed with Abby O'Connor and Mitchell Gans called the special power of appointment trust, it seems as though you don't have to worry about the reciprocal trust doctrine. But why take the chance? If you're really going to try to do something, even if you're single, do it in a self-settled trust jurisdiction, because that way you'll at least get the benefit of that. And the IRS has ruled, and it's ruled it more than one time, that if you create a trust in a jurisdiction for yourself and creditors under the jurisdiction governing that trust can't attach the assets of these, can't attach the assets for debts of the settlor, it's not includable in the settlor's estate. Very, very important concept to keep in mind as you begin to build your trusts.
Ed, what do you think?
Yeah, and I agree with Jonathan, but I'll add one caveat to that. And Marty, I think you make an important point. If they're uncrossed and you're left with two discretionary trusts, and it is an adapt state, then there is a question, hey, do they, it's an extra backstop, an extra level of protection there, but it may depend on how the two drafts, the two reciprocal, non-reciprocal trusts are drafted. If I have one that grants an income interest to the spouse and one that doesn't, well, the one that grants the income interest to the spouse may have a 2036 problem, whether it's an adapt state or not, whereas if they're both discretionary trust, and of course, one of the other differences might be some people might add a 5x5 power or something like that. But if there were just a discretionary interest and one's a spray trust and one's income only, discretionary only to the spouse, then I think your point is well taken. It's an extra backstop, an extra argument against the reciprocal trust, coming to disastrous results, because if I've got the backstop there, that the DAPT, that makes two arguments that the IRS has to come at, to get that retained interest inclusion, so it's an extra level of protection there in most cases, but it might depend on how the two trusts are designed. If I have an income requirement in the trust, which we don't usually like to do with SLATs, but might be there with some drafters, that might not be as protected. Does that make sense?
Yeah,
it does make sense. And let me add one other thing. The IRS is looking for the low-hanging fruit. The more you can distinguish yourself from the other trusts, the more you can distinguish yourself from any of the cases which have been adverse for taxpayers, the better off you're going to be, because the IRS may not view you as low-hanging fruit. And the IRS likes that low-hanging fruit. It doesn't have to put out much of an effort, and yet it can do what it wants to do, which is try to collect tax.
Let me add one other point, and I also have to, I think, beg forgiveness because I left out one of the preeminent newer asset protection jurisdictions. Ed, which jurisdiction did I shamefully leave out of the list?
Well, Ohio, of course.
There you go.
But I think we're up to like 20 now, aren't we? I mean, we got West Virginia, Indiana, Michigan, and near me, and
Connecticut.
It seems like you hear about a new one every few months. It seems like.
Yeah, I don't think it's the outlier that people had thought when it was first started in Alaska. So forgive me for not mentioning Ohio, but we've now mentioned Ohio. Yeah. One last comment just apropos to this, and then Ed's going to go through the agenda, and then we're going to go through the presentation. It's very clear to me, and this just amplifies Jonathan's comment about low-hanging fruit. The Smaldino case at the end of 2020 and very recently the Sorensen case make it very clear that if the IRS can attack and successfully unravel a transaction because the taxpayers didn't follow formalities, why should they get into like negotiating or sparring with somebody like a Jonathan or an Ed on a complex 2036 A2 issue if they can just say, hey, you the taxpayer ignored all the formalities, why should we be bound by this? So to me, one of the real benefits of using an institutional trustee on all these transactions is they're not going to simply willy-nilly do something like Aunt Jane or Uncle Joe are going to do because you called them up and said, send me a check or do this or that. They're going to have formalities. They're going to understand how a trust is administered. There's going to be a distribution committee approving a distribution. They're not going to permit a swap of assets until somebody's done whatever due diligence they feel is necessary. So I think using institutional trustees should be the default answer on all plans. And please don't, throw arrows my way because you disagree. Just my thought on that. Ed, why don't you take us through the agenda of what we're going to try to get through?
Okay, great. And this, the genesis of this came from a discussion that Jonathan and I led at the Asset Protection Committee at AgTech that got a lot of interest. And I think it's because there's been a lot of questions about what we call backdoor interest in SLATs. And what we're referring to is at some point, if the grantor of the SLAT becomes a beneficiary either through a power of appointment or trust protector, any number of different ways, what are the ramifications of that for estate inclusion and also for asset protection? And these are all kind of intertwined together. So what we're going to talk about is a little bit of the balancing act that we have, when clients ask us to create this trust, but then have some kind of backdoor interest. And then we want to talk a little bit about the state law, how that kind of informs not just federal law that we're worried about, but sometimes we're worried about what state law is going to say to any kind of backdoor interest, and what states have done recently statutorily to kind of fix this and make it a little bit more debtor friendly, a little bit better planning options in some states. We'll talk about what states have fixed what where. And then, the Jonathan Spat article we'll go into, and other ways that we can add a grantor back, what is the level of risk, behind these, whether it's a trust protector or a power of appointment holder. What's the risk from a credit protection standpoint and estate tax? And then we'll talk about 2036 in general with a couple cases that kind of highlight the points in Jonathan's 2009 PLR too. And then we'll talk about some other ways SLATs benefits might be destroyed, problems with floating spouses and things like that, grantor trust tax reimbursement clauses, how that kind of plays into the whole issue as well, and then kind of sum it up from there. But let's go ahead and start with just the balancing act in general, Marty. I mean, if I'm doing planning for the billionaire client, they can afford to give $10 million away and without batting an eye, and don't need any kind of backdoor access. But of course, the SLATs have been so popular in recent years because people want to have some kind of backdoor access, and it really is. It sounds too good to be true, but for the most part, it is a great planning tool. And in fact, we've got some favorable case law. Not only can your spouse have an interest in trust and not have it be included in their estate, but in the state of Gutsch's case, which was acquiesced by the IRS, you can even live in in the home residence, vacation home or whatever that's owned by the SLAT, that because you've got favorable case law there that says, well, it's at the sufferance of the donee spouse that is the beneficiary. If she has the rights to the residence, she can let whoever she wants, or whoever he wants, use the residence as a guest, right? And so that's some favorable case law as well that surprises a lot of people, frankly, right?
Well, Ed, let me add that Gutsch's is an extremely important case because Guy gives his home to his wife. He continues to live there with her. IRS comes in and says, look, 2036A1 applies even if there is no legally enforceable right. And the IRS lost the case, but then it not only acquiesced, it issued Revenue Ruling 70-155, in which it said, we will not go after the inclusion in the estate if the trust that one spouse creates for the other allows the spouse who was the grantor to continue to enjoy the property. Extremely important. Now, it may only be limited to homes. We don't know. I think it can be more broadly and should be more broadly read, but it's a very, very favorable case.
Well, I think that's a good point, Jonathan. If it were artwork in the home worth $1 million, do you see any difference? It seems to me like that would be the same kind of rationale.
I completely agree. And this, of course, is great because again, you're talking about having a healthy marriage and one that will continue. And as we all know, there are a lot of divorces in the United States. It doesn't matter what religion, net worth, or whatever, divorces occur. So you always take that risk by creating a trust for your spouse. but this says that your spouse can allow you to continue to enjoy the property during the term that the spouse is a beneficiary anyway. And we're going to get into, well, suppose your spouse dies first. What then?
And that's the genesis of this talk, because our clients are always asking, well, wait a minute, what if, my spouse dies early? This is great. I've got this backdoor access. I can, my wife will let me live in the home and the vacation home, etc. But what happens if they die first? The donee spouse dies first. That's the tricky thing. And of course, sometimes people will ask, this isn't quite as common. They probably should ask it, but what if there's a divorce? That's another issue too. That liberal access that is granted in the happy marriage kind of discontinues at that point, right? And so we have our clients asking us about, well, okay, what are my options? How can I still get access to the funds in the same way after the donee spouse has died? Marty, do you ever have clients that want to have their cake and eat it too?
No. They're very happy never to have access to their money. The point I was going to add is when you gave the example, the billionaire client should certainly be able to give away their approximately 26 million for the couple exemption and not have to worry about it. When you have a client worth $30 million, how do you give away 26? You can't. 40 million, 50 million. What point can you really give it away? And I think that one of the things practitioners should be mindful of, if the clients will listen, is the better thing to do is to get a wealth advisor to do some financial modeling and show the clients what this all looks like. And another thing to keep in mind, which we're not going to get into, but I just want to put it out there quick, insurance planning should be part and parcel of this. If you have a client under $50 million that's giving away 26 million, just throwing out a rough approximate number, you want to have some financial modeling, because that helps reinforce that the client understands what they're doing. You don't want a client later coming back saying, gee, I didn't really understand. And you also, if there's financial gaps in the plan, insurance can often fill them. And it should be the client's prerogative to make the decision whether or not they want to go down that route. I mean, a very simple way to address the issue of premature death of a spouse, I set up a SLAT for my wife. God forbid my wife dies prematurely. How do I get at the trust? Well, when I did my SLAT in 2012, people weren't doing SPATs and hybrid DAPs. It really wasn't talked about. I have no access. But insurance on her life held in her trust is a very simple solution. So, we're going to talk about a lot of the legal issues and what can be done legally, for example, for a spouse to appoint back to the donor spouse. But don't overlook the basics of just good financial planning and modeling and life insurance, or disability insurance, or long-term care coverage to fill some of those financial gaps.
Absolutely, Marty. And, of course, that's more palatable when people are healthy and younger than when they're older and don't want to pay large insurance premiums. But it's a great point, because it's a much safer alternative to get to the same place,
But I think whether the client finds the insurance too costly or not should be the client's decision. But taking them down that path of planning helps them understand better. Because listen, if we explain as a lawyer what the consequences are, and an insurance consultant and a wealth advisor explain the consequences from their lens, the client's going to hear something a little different each time, because we all explain it, each professional differently. And I think it'll help inform the client better. But once you dollarize the concept, they can make a decision. And you know what? For the older couple, it may not be life insurance because it may be too costly, but they may seriously consider long-term care coverage that they rejected earlier, because before they gave away 40% of their wealth, they weren't worried. Now they are.
Mm-hmm.
Why don't you take the next slide, Ed? And after you say the first line, I want to repeat it, because I think it's the most important sentence of the whole program.
Okay, and so the one thing that we have to balance, though, is we have all these creative methods under state law where the donor spouse, the grantor spouse can have access, and perhaps safely for a state law perspective as well. But we kind of have to remember that the more access that's given to the grantor, as a general rule, eventually, the greater the chance of a state inclusion and creditor access for state law as well. We're going to go through a few more cases other than the McCabe case, but we put this one first. I just referenced the McCabe case because the husband in this particular case set up a SLAT before we called them SLATs, right? This was in the 60s, the 50s that he set it up. He set it up with his longtime friend and business associate as trustee with income and principal for emergencies for spouse and remainder to children, kind of a typical, SLAT, right? 20 years after the inception, the wife sent a letter to its trustee requesting distributions to be made to help her husband out with some financial needs that he had, and trustee made a few payments, not to the donee spouse, but to the donor spouse. Unfortunately, and the court found that was a 2036 retained interest, even though it was arguably ultra virus, right? I mean, he wasn't a beneficiary of the trust. It was at the request of the donee spouse beneficiary. And just to point out that the bad facts make the law sometimes in these particular cases, and that might have been an immaculately drafted trust, but 2036 could still apply, and we have to keep that in mind.
Right. Let me mention that McCabe is really a case of kind of an implied understanding that if the husband in this case needed some benefit from the trust assets, it would be given to him. Now, what they should have done, of course, was to make the distribution to the wife, and because there was an unlimited marital deduction when it took place, she could have simply given it to her husband. So it's not just the terms of the trust, it's the actions in administering the trust, which is often going to determine whether or not you're going to get the result you want, which is asset protection and estate tax exclusion as a general matter. So please don't say this is a perfectly drafted trust. There's no way the IRS or a creditor can get at it. If you slip with respect to the administration, you may be losing the game.
Really important point, what Jonathan just said, because that's what we're seeing in the cases. Smaldino, Sorensen, they didn't administer the plans properly. And that will just undermine even the most perfect of trusts.
And we see that in quite a few of the 2036 cases, and we'll go through a couple more later too, where an institutional trustee would have gone a long way to preventing the fuzzy administration that caused the problems in the particular case. So we got kind of a balancing act here, and we're hopefully going to give some guidance here on the overlapping issues of, okay, there's a 2036 risk, but where is the level of risk? As Jonathan said, you can be a discretionary beneficiary. That doesn't mean automatic inclusion as long as the creditors can't get at it, and we'll talk about that particular rule. So, where is the sweet spot? And this may differ from client to client. You guys know, everybody says they want to keep it simple. And sometimes people say they don't want to use institutional trustees. And we tried, as practitioners, you might try to accommodate that. But, we're trying to do what the client wants, and they try to have conflicting goals sometimes to keep it simple, keep it cheap, and, keep the access as much as possible, and those may not necessarily be compatible goals, right? So,
right. Let me mention in kind of an analogous area, grantor trust. If you create a trust, say for your spouse, and your spouse can only get a distribution with the consent of an adverse party, well, that means that you don't have a grantor trust by reason of her eligibility to receive a distribution, because all of the grantor trust provisions have an adverse party consent as an exception to the grantor trust rule in that section, like section 674 and 677 and so on. But the case law suggests that just because someone appears to be an adverse party, for example, I create a trust for my wife and I have my son as the remainder beneficiary, and I say, but the trustee can give distributions to my wife only with the consent of my son. Well, it appears he's an adverse party. But the courts say we're going to look beyond the mere words on the page. We're going to look at the family relationship, including the fact that perhaps the grantor would be angry at the child if the child did not go along with it. And that's another reason to have an independent fiduciary, perhaps even an institutional fiduciary, if you really want to maximize the most you can get and reduce the risk of estate tax inclusion and creditor attachment.
I think a lot of our colleagues, some very, very bright colleagues that I've spoken to, tell me that their default or typical SLAT plan is to set up home state trusts, both in the same state, have the husband as the trustee on the wife's trust, and the wife is the trustee on the husband's trust. And when I've suggested, gee, I think it's safer, why not put one in Ohio What's your company's name, Ed?
Huntington, yeah.
Huntington is trustee, and one in Alaska with Peak is trustee. You have different jurisdictions, different state laws, and different institutions. It's much safer. And the comment back to me was, I agree with you, but clients don't want to spend the money. They don't want the complexity, and they don't want institutions. Jonathan, I'm going to let you comment, but I think two things. One, I think a lot of it is how we as practitioners explain the options and the implications to the client. And the second is, if a client is going to make those decisions, it's certainly the client's prerogative. We can't tell them what to do. We can only make suggestions. You may want to think about putting in writing to the client that, we discussed the benefits of having institutions and DAP jurisdictions, and you opted to have the trust in the home state with family member trustees. Cover yourself, protect yourself.
Although the IRS might, Marty, or a creditor might come in and say, yes, you gave that advice, Marty, to protect yourself, but you've really harmed the client because the client didn't follow that advice. So maybe that's a situation where you don't want to say anything. Let me also mention one other thing.
I don't agree with that.
One other
That's
thing
another
that
discussion.
one other thing that I've suggested is that don't have the trustee who is going to be asked to make the invasion for someone be a trustee at inception. Set it up. Maybe you even have family members in there as trustees. But before you do anything significant, appoint an independent trustee who wasn't even aware at the time that the trust was set up. That pretty much should foreclose the IRS or a creditor saying, oh, there was an implied understanding that, going back to the McCabe place, that Mr. McCabe would get a distribution. Because if the trustee didn't even know about the existence of the trust when it was created, I think you go very, very far in foreclosing the argument of an implied understanding.
Right.
And that's
It's
a
harder
simple
for the
step to
court to
take.
defer.
You have the trust protector change trustees before you do something significant. It's a nice piece of insurance. Why not? Ed?
Well, let's go on to the next slide and next topics, Marty. And Jonathan and I had some back and forth on this particular issue, but I worry when we're talking about non-DAP states here. We have a considerable number, dozens of states are following the UTC, right? So this is affecting a lot of our listeners here. The UTC, when I have a kind of a backdoor interest, what does the rule against self-settled trust in the Uniform Trust Code read? And we've kind of quoted it right here. It basically allows a creditor to get at the maximum amount that can be distributed for the settlor's benefit. But something unique that I pointed out, and Jonathan and I batted this back and forth, it doesn't say whether it can be distributed by the trustee or distributed by, a power holder, or the trustee with, at the direction of the power holder, or by a trust protector. And so I think, particularly if you're in a UTC state that hasn't kind of clarified this particular position, I wonder if a self-settled trust treatment might be created if I set up a SLAT and I have a trust protector, and I'm assuming not a DAP state, but if I set up a SLAT for my wife and I have a trust protector or a power holder, whether it be my wife or anybody else, with the ability to appoint back to me, does that kind of create a self-settled trust? And directly, now under the restatement, Jonathan reminded me, the restatement kind of says what's the power of the trustee, doesn't talk about any other power holders or, trust protectors or anything like that. But I think the tricky issue is if I'm kind of worried about creditor inclusion, because I'm worried about self-settled trust status, so I'm not in a DAP state, if I'm kind of worried if they're a judge looking at this and there's, creditors on the horizon, and they see some kind of trust protector clause or some kind of power appointment clause enabling appointment back to the settlor, I worry that it creates a self-settled trust. Jonathan, what's your take on it?
Well, I think you're right, Ed, except if you look at the commentary, which in a sense is kind of like the regulations to a code provision, it says that they're talking about the maximum amount that the trustee could distribute to the settlor. So, if you're in a UTC, Uniform Trust Code state, and you have section 505A2, if you look at the commentary, unless it's something contrary in the legislative history under state law, it should be read as saying it only applies to the extent that the trustee could do it. Now, let me point out, it's not just a trustee. I think you have to worry about all fiduciaries, including perhaps a trust protector. And some believe that all trust protectors are in fact fiduciaries, except in Alaska, where it explicitly states that a trust protector, unless the instrument expressly provides otherwise, is not acting under a fiduciary obligation at all. But again, you're going to be better off if you go to a DAP state, like now we have Ohio, Delaware, South Dakota. There are, as Ed said, there are about 20 of them. That's really where you want to go. However, everybody worries about if the settlor lives in a state that doesn't have a domestic asset protection trust legislation, say in California or New York, are you really going to get the benefit of that merely because you've created the trust in another jurisdiction? We can talk more about that, how to wall off creditors from the grantor's home state. And keep in mind that if a judge determines that the creditors could reach it, you're going to have a state tax inclusion under Revenue Ruling 76-103 and 77-378. So this is something to really think through. In fact, I'm going to state, if you want to have a SLAT and you do not want to maximize the risk of estate tax inclusion or creditor access, you need to create it in a DAP jurisdiction. It's usually not that expensive. Good trustees in the 20+ jurisdictions where it can be done. And really, if you're trying to do this, it really makes sense to have it located there and cut out everybody from the home state. Don't have a trust protector. Don't have anybody who's in the picture in a state that doesn't have DAP jurisdiction.
That's really the ideal that you want to go for, the gold standard. And not every client is going to be comfortable with that. But let me just sort of make a reality check to reinforce what Jonathan just said and what we've said several times in the program in terms of going to a jurisdiction that permits self-settled trust. I think we all agree being in a self-settled trust jurisdiction with an institutional trustee is just a better approach for all these reasons. I think one of the things that needs to be considered in 2012, the exemption amount was 5 million. Before 2012, the exemption amount, a few years before was I think in 2003 was $1 million. So when somebody was setting up a trust like a SLAT or non-reciprocal SLAT, how much money was involved? The exemption now is close to $13 million. So if even one spouse is going to use most of their exemption, you're talking a $10 to $12 million transfer. Relative to the amounts that many of these transfers involve, it's kind of hard for a client to argue, gee, I don't want to spend the X dollars a year on an institution and I don't want to spend the few grand extra to get it into a trust-friendly jurisdiction. The amount of money being transferred, the wealth being transferred, and a lot of the planning that we're looking at, the whole topic of this discussion is so large compared to what it historically was on the small end that I think the hesitancy to incur the costs of a better plan just don't really make a lot of sense. I think the one exception to that, which is where the topic Ed is talking about is really critical, is where you have a younger couple, 2 surgeons, and they want to have asset protection and they want to protect assets. So they're starting their planning today, even though they're not worried about estate tax. The numbers are going to be smaller. They probably have to start in their home state because the cost of the more complex planning relative to what they're putting in may be significant. But for people doing estate planning, I think that the whole dynamic has changed. Ed?
Well, let's move to the next slide, Marty. We've got the citations for what we just talked about in the restatement, that is slightly different than what the UTC says, at least some of the wording of it. Of course, my worry is if the UTC hasn't been clarified that, the judge in Peoria, so to speak, is just not going to be looking at the comments of the UTC, or, they're going to read the statute and say, well, this sounds like it's, susceptible to creditors in this particular state. I do want to point out on the next slide, though, that UTC section 505 is probably one of the most, changed it's probably one of the least uniform provisions in the Uniform Trust Code, because almost every state has modified UTC Section 505 at least somewhat. Um, I just put an example of how Ohio clarified its particular state statute in this case. So even if you don't qualify under Ohio's DAP statute, you still have some protection, because a power holder ability to appoint back to the grantor spouse does not create self-settled trust treatment. But my worry is if I'm in a UTC state that hasn't clarified that it may cause an issue. And then, Jonathan pointed out in the last bullet point here that, under Alaska law, you may have some different, issues there, but definitely look to your specific state statute, UTC version of 505. That's all I had on that slide there, Marty. But so the other thing I pointed out here is that a lot of state statutes have, state legislatures have appointed in recent years, kind of clarified issues regarding inter vivos Q-tips. And we're not primarily talking about inter vivos Q-tip or marital trust today. We're talking about mostly SLATs that have, that are completed gifts, not designed to qualify or take the marital deduction, right? But there's a lot of states that have kind of passed this statute to prevent, creditor access of, when the funds come after the donee spouse's death back to the donor spouse in trust. And look to your particular state statute on the next slide. We've got a list of all the different state statutes. The ones that have the asterisk on them have addressed the issue for not just for marital trust, but also for SLATs. But by all means, here's a few different states that have addressed this particular issue of creditor access, what we call backdoor access for the settlor after the donee spouse's death. So take a look at that. The reason they're doing that is to prevent, to allow this kind of planning, for SLATs to eventually benefit the grantor spouse again.
Ed, I'm sure many understand it, but maybe you could just take a second and explain how the backdoor Q-tip, where you appoint back, just so it's clear to everybody in case somebody's not familiar with it.
Right, and the inter vivos Q-tip in marital trust is important to remember, because you have a specific regulatory blessing in that particular regard, and we had that on the one slide previously, Marty, just to kind of, if you want to go back to that, just to kind of give the citation to people. But if I have an inter vivos Q-tip that I set up for my spouse, and it comes back to me, perhaps my surviving spouse has a testamentary power of appointment, this would be not uncommon, right? An inter vivos Q-tip trust can grant that to my donee spouse, and she can appoint it. If she dies first, she can appoint it back into a trust for me. It might even be a Q-tip trust for me. It could be a split between an AB, bypass, and a credit shelter trust. That's still perfectly okay. And the IRS has kind of blessed this particular strategy, and they've issued particular regulations. What has worried people, though, is even though there's a Treasury regulation blessing it for 2036 and 2038 purposes, some people worry, well, but if there's creditor access under state law, couldn't that cause inclusion in the grantor spouse's estate if that happens? And so that's the genesis of all the different states kind of fixing their statutes on the next page here. Basically just kind of making sure that we don't have creditor access, that we can set up inter vivos marital trusts that come back to the grantor spouse without any asset protection or estate tax negatives.
Ed, let's try to frame this so it's clearer for people. And maybe it is, but just it'll help me to make it clear. So if you have a client whose transfers are sufficient enough, I think we all agree you're better off going to a DAP jurisdiction than using an institutional trustee. If the client, the transfers to the trust are going to be more modest, and the cost and hassle of going to a DAP jurisdiction and naming an institution are just not comfortable for the client, if you're in a jurisdiction that permits, as we kind of called it in our title, backdoor SLATs, where you can set up a SLAT, and I'm just going to use husband and wife to keep it simple. Husband sets up a SLAT for wife. Wife gets a testamentary power of appointment to appoint back let's say in a credit shelter type trust, just to illustrate to the husband, if state law sanctions that, and that's on slide 18 with the asterisk, then that should be a good deal. If state law
Right.
doesn't sanction it and it's too costly and the client's not comfortable going to adapt jurisdiction, the other alternative might be to create an inter vivos Q-tip, because your state law, if it sanctions that, and then the let's say the wife, to keep the illustration simple, can appoint back with a testimony power under her will, like in a credit shelter or like you said, Q-tip AB type trust plan to the husband. So if your state does that, that's fine. If you have a situation where your state doesn't permit either the backdoor Q-tip or the backdoor SLAT, and the client doesn't want to go to adapt jurisdiction, you can't really do this kind of planning.
It's a lot more dangerous, that's for sure. You might
Right.
not even want to do it in the first place, and not just
Right.
warn the client, but just don't do it.
Right. I wouldn't do it because you have no leg to stand on. But that's sort of a sequence of 4 levels
Right.
of how maybe people might view this, if that helps.
Great summary.
One of the things is that if you say, I just don't want to deal with an institutional trustee, having a power to remove and replace that trustee may go far in allowing the client to say, okay, I'll go with bank X or trust company Y. And if I get upset with them or my family does, we can remove them. And that's not going to cause a creditor problem. It's not going to cause a state tax inclusion problem as a general rule. The other thing is that almost always, because we now have 20 jurisdictions, almost always you'll have a friend, a fraternity brother or a sorority sister from college who would act as, say, an administrative trustee, so you get the benefit of that state's particular law. So that's something you can go ahead and do. In the Iannotti case, which was decided in New York, a man created a trust and it allowed a trust protector to put him back in as a beneficiary. And even though he had not been put back in as a beneficiary, the New York courts held, and these are lower court cases, so it's not the New York Court of Appeals, the highest court of our state, but went ahead and said the fact that he could be added in was sufficient. But keep in mind that the person who get added in was a fiduciary under New York law. So again, if you're going to do something about allowing someone to add the grantor back in, not only should you go to a state which doesn't have bad law on that, but you also should make sure that the person is acting in a non-fiduciary capacity.
Good point. Let me throw another idea back at you. Let's say we do have a listener who's in a state that hasn't fixed this issue. They're not an adapt state. What about conditioning the donee spouse's power to appoint back to the grantor on them appointing to a trust and adapt state? In other words, you can put a condition on the power of appointment. Say, I grant my donee spouse the testamentary power to appoint, but they may only appoint to a trust for the benefit of the grantor spouse if said trust qualifies under adapt state statute with adapt state trustee. In other words, that might basically say, look, if you do have this backdoor access, it has to come back through the back door into adapt state trust. What do you guys think of something like that? Putting a condition on the power of appointment.
Why not do a 2-step plan? Have the spouse first appoint to a trust in adapt jurisdiction. And then after you have a trust that's in adapt, you decant it, put it in adapt jurisdiction, then exercise the power.
Well, I think those are good ideas, but one of the things that I think would make a judge a little bit unhappy is you've tried to block me in so many ways. I saw what you were trying to do, and I'm just not going to let you get away with it. I can't tell you, but that is kind of my reaction. Don't be, too cute by half. Start in adapt jurisdiction. If your client won't do that, well, you've got to tell the client, look, you hate paying fiduciaries, you hate worse paying lawyers. Well, guess what? If you do it in the home state, I'm going to make a lot more money when this is attacked either by a creditor or by the IRS. So go ahead and do it that way, because you're going to make me a lot wealthier. And every time I've said something like that to a client, guess what? They don't want to pay me more. I can't understand it. Ed, I know you and Marty have never suffered from that, but I had clients who didn't like paying legal fees. And now you're telling them, yeah, we're going to do it your way, but I'll make more money in the long run. That really, at least my clients were irked by that. And typically they would come around with something that was really more sensible and in their better interest.
I just, let me interject a comment that kind of covers something that we've talked a couple of times about. I said earlier that I have a number of colleagues who tell me that they agree with the concept of adapt jurisdiction, but their clients want home state with family trustees. I think part of the issue is if you explain to the client some of the things Jonathan just said now, and that he made a comment a few minutes ago that, oh, you don't want a corporate trustee, fine. What if we name Uncle Joe as the trust protector and give him unfettered right to remove and replace the trustee? There's so many ways, if the client can verbalize the concerns that they have about going to another jurisdiction, about an institutional trustee, almost all those concerns I think can be addressed in ways that are helpful. And in the end of the line, it's just a safer plan to do it in adapt jurisdiction with an institution. Ed,
Well,
we go onward.
let's onward and upward. You know, there's a good, we mentioned 20 or so states. I don't know how many it is, but there's a link to the various state comparison charts that I know you've contributed to with David Shaftel and Alaska, Jonathan, but there's a link to the various state statutes.
It's really worth your while to make a copy of this and go ahead and keep a copy handy. Now it changes. Dave keeps it updated. It's wonderful. You can see all the differences, but you know, the client probably will have some feelings about it. Well, gee, I'm in California. I'd like to go to Nevada because it's close at hand. Someone else might say, Alaska, you know, the land of ice and snow. No, I don't want to go there. Oh, wait a minute. That'll be tougher for the creditor. So I do want to go there. So these things, they will balance different ways for different clients. But go ahead and get that Shaftel comparison of the DAP states, and I think it will provide you with some guidance.
So Ed, should we do adapt instead of a SLAT?
Well, you know, there's some advantages to not going to the SLAT immediately, but yet still doing the trust in adapt jurisdiction. And that kind of is a good segue to your article, Jonathan, about maybe some of the advantages to the SPAT. Why don't you, this might be a good time for you to kind of introduce the thrust of your article, and then we can make some commentary on that, Jonathan.
I thought we were going to tease him and not let him talk about SPATs. He was so excited. He was so excited.
Well, this was an idea I came up with in 2019, and Abby O'Connor, who's a wonderful estate planner in Anchorage, and my dear friend Mitchell Gans, who's a professor of law at Hofstra and at the NYU Masters in Tax program. This is the notion. Again, Ed can say, well, you know, maybe if you're in a jurisdiction that's got the Uniform Trust Code, maybe the judge won't read the commentary and forget about it. But it basically says create a trust for your family. So I'd create a trust, say, for my wife and kids, or just for my descendants. And the trustee is prohibited from making a discretionary distribution to me. But I name my 3 best friends. And in fact, when I did this, I named my 3 oldest adult and competent cousins living at any given time, because I have confidence in them. And any one of them could appoint property from the trust back to me. Now you might say, well, can they put it back in trust for you? Nope, they've got to appoint it outright. Why? Because if I need the money, I want the money. Having a trust for me doesn't do any good. But what they can do is any one of them can exercise this non-fiduciary special power of appointment directly to me, not in trust, but directly to me. And I think we probably all agree that if someone holds a special power of appointment, which theoretically could be exercised to anybody in the world other than the person's estate creditors or the creditors of their estate, that it's not going to be considered a self-settled trust. So I go ahead, even in New York, I create a trust and I name, say, the Bank of New York as my trustee, and it's only for my descendants, but I give my 3 eldest adult and competent cousins the power to appoint any part of the property to me. And that, in theory, is not subject to the claims of my creditors, and therefore it's not includable in my estate, because there is a 1980 private letter ruling, and there is a 2009 private letter ruling, and there are cases which say that if creditors can't attach it, then it's not going to be in your estate unless you retain a power, like a power of appointment yourself, which would cause estate tax inclusion under section 2036A2 or 2038. So this special power of appointment trust, a SPAT, is another thing you can do to reduce the risk of a successful attack by a creditor or by the IRS. Again, I said it before, I said it again, and I'll say it one more time. The IRS wants the easy money. It wants the low-hanging fruit. And if you do a SPAT, man, the IRS has got to think, well, gee, they got all this law on their side. If they've appointed it, in fact, one of the things you might do is actually divide the trust before you even make a distribution from it. So you divide your trust into various parts and maybe change the terms, maybe some. No one has the power to appoint it back to the grantor. And that really will reduce the risk of it happening. Now, in theory, this would work in New York, California, anywhere, because under those state laws, you have to have the ability to get it back in the consent of the trustee. Here, the trustee is prohibited from giving it to you. It's just these people hold non-fiduciary special powers of appointment. And that's not going to subject it to the claims of the grantor's creditors, even though theoretically the power of appointment could be exercised in favor of the grantor. So if you really want to go the extra mile, I would suggest you consider a special power of appointment trust. And I don't know, yeah, it's in the materials, and it's from the February 2019 issue of Estate Planning Magazine. And there are the two, by the way, there are two of the private letter rulings, that 98 private letter ruling and 2009, and there's also one from 1980 as well. Plus, there are cases out there which suggest, for example, there's a case, and I think maybe we're going to talk about it, Estate of German, where Mrs. German, who was a resident of Pennsylvania, created a trust in Maryland. One of her sons lived there, and he was one of the 4 trustees. And he could appoint property back to his mother. She was the grantor. And when Mrs. German died, the IRS said, aha, it's includable in her estate. And the tax court said, well, why is it in her estate? Because creditors can attach it, the IRS said. And the tax court said, prove to us that under Maryland law, which governed the trust, remember, Mrs. German was a Pennsylvania resident at the time she created the trust, and she was a Floridian at the time she died. But the court said, we're going to look at the law that controls the trust, which was Maryland. And the IRS could not prove, I was tangentially involved in this case, the IRS fell on its face in trying to prove that creditors under Maryland law could attach the assets in the trust. So you've got a lot of law on your side if you choose the right jurisdiction and you administer the trust the right way. And my attitude is, if your client is going to all this bother and all the expense to try to create non-reciprocal trust with a backdoor for the grantor, that I would consider something like a SPAT for at least one of the spouses to do it, or to do it for yourself, rather than just saying, well, I'm going to create a DAP and I'm going to do it in Alaska or Ohio or South Dakota. Maybe what you should consider is a SPAT. But I will urge you, if you do it, don't say, well, it can be done anywhere. Jonathan says in California, New York, wherever, go to a DAP jurisdiction. So you'll get, belt and suspenders when you go forward.
Or at least a state that's fixed its version of UTC 505A2, with a clear statute.
Let me make a couple of comments. One, Jonathan said a few things very quickly. I just want to unpack a little because they're important. Everything you said was important, Jonathan, but let me just emphasize a few. One, Jonathan said you can do this for yourself. So even though our topic is backdoor SLATs, we don't want to focus only on married couples. Lots of clients are single. You can do a SPAT or a DAPT or a hybrid DAPT or some combination for yourself. And if you have the wherewithal and you're not sure which technique, because no one can weigh, which technique is safer, go to Alaska and do a SPAT, go to Ohio and do a hybrid DAPT, and go to Nevada and do a regular DAPT. I mean, you don't have to put all your eggs in one basket, but this concept works, these concepts work for single people. Very important. Second, so often, and there's so many discussions about SLAT, 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 SLAT. It's like the acronym du jour that keeps getting talked about. There's no reason that you should do non-reciprocal SLATs for any client. Why not do a hybrid DAP and a SLAT and a SPAT? These are the grace case, as I read it. The fundamental point of the reciprocal trust doctrine is you can't be in the same economic position after the trusts are set up as before. If I create a SPAT for my wife that has a power for Ed, well, he'll never give me money. Maybe that's a bad example. But if I give Ed a special or limited power of appointment, and I create otherwise a SLAT with that SPAT provision in it for my wife, and she creates for me a trust and she doesn't have a SPAT power, my economic position is much stronger than hers because I have that access point she doesn't have. I think you've done a great deal to differentiate for purposes of the reciprocal trust doctrine. And Jonathan, let me ask you a question. So if I do a trust, any kind of trust, and I give Ed Morrow, because I trust him, I like him, and I don't think he's going to abuse the power, I give Ed the broadest limited power of appointment that I can to appoint to anyone other than himself, his creditors, his estate, creditors of his estate. How does that differ? Does it differ at all from a SPAT? Haven't I just created a SPAT because he can appoint it to me if he chooses?
He can, but what you want to do is you don't want to allow the power holders to appoint it to themselves for two good reasons. Number one, they may have a creditor problem, an estate tax inclusion problem, and on top of that, you want to be able to get it back to you or your family. So one of the things I always do is when I say that my three cousins can go ahead, any one of my three cousins can appoint it to me, again, directly, not in trust, because I don't care that it's in trust for me. What I want is the money at the time I need it. But the other thing is you want to be pretty doggone sure that it's going to be exercised in a way that makes sense. And for example, if I name you and Ed as the people who hold these powers of appointment, you guys might get together and say, let's screw Jonathan by appointing it to his grandson, James. Well, I don't want that. So what I do is I say, in order for either of you to exercise that power, you need the consent of my lawyer. And I am pretty sure that my lawyer is not going to consent to your exercising the power in favor of my grandson, James. It really puts you in a very, very secure position. And I think it's better than a standard DAP. And I can say that, remember, I'm the guy who came up with DAPs in the United States. So I'm cutting down from what I, preach for about, 20 years. To do it in Alaska or do it in Nevada or do it in someplace else because they had the best laws. But now I think that doing, a special power of appointment trust is safer. I mean, that's my attitude. Ed and Marty, what do you think? Do you think that a SPAT is safer?
Let me, the point I was trying to make, Jonathan, is for people that say that SPATs don't work. I understand what you just said, how you can narrow to make it safer. But conceptually, the idea of giving Ed Morrow a limited power to a point that could include back to me, in a sense, it's not all that different than the kinds of limited or special powers we've all used for a very long time. So what I was trying to get at, and you took it a different way, but I think I just wanted you to comment about people that say, no, it can't possibly work. But why is it different than the typical limited powers of appointment that we've given for many decades in trust and common drafting? It's just a more refined version in a sense.
That's
no one gets up and no one gets alarmed about the limited powers that we've commonly used.
Well, the one time you may want to limit it so it can't be appointed back to the grantor is where you don't want it to be a grantor trust. Because even if you're not a current beneficiary, the fact that the three power holders could appoint it to you, unless they truly are adverse parties, and if they're adverse parties, they may have a gift tax problem in exercising it in your favor. You can go ahead and do it, but it's going to be a grantor trust, which you may want anyway, because you want to be able to have the ability on a gift tax free basis under Revenue Ruling 2004-64, of which there are many proposals in Congress to change the result, would allow you to pay the income tax on the income that the trust earns, which means that you even get more money out of your estate. One of the most powerful things you can do is to create a grantor trust. In fact, one of the things, and Ed, I know that you and Marty will agree, if you have a client with considerable wealth, you ought to have them create a grantor trust right now. Do it before it's all closed down, because I think if they do have some sort of tax reform, the ability to use a grantor trust to avoid estate tax inclusion or to avoid gift tax is it's just a wonderful way to do it. So consider creating grantor trusts.
I think it's back in the Green Book, isn't it?
It's
For
there.
Yeah.
It's
It
back.
is, and Ed and
Wasn't
Marty,
that
I think.
Freddy Krueger, one of the horror movies? He's back. Oh no,
Yeah.
a different horror movie. One of the horror movies.
And
He's
in
back.
fact, in tax notes today, there was a story about 4 senators, including Bernie Sanders and um, Chris Van Hollen, have written to Janet Yellen, the Secretary of the Treasury, and therefore she's in control of the IRS, saying, don't wait for legislation. By regulation, go ahead and stop people doing things like creating grantor trusts. So you have this so-called tax burn where you're paying the income tax on it. Now, whether they have the power to do that by regulation as opposed to a change in the law, I'm not ready to address right now, but there's an awful lot of focus on it because even the congressmen and senators have finally awakened that it's one of the most powerful planning options you can do for a client. So my advice is, if you have wealthy clients, and this is for the lawyers and the accountants and the bankers and others who are listening on their own, you ought to create one for yourself. Have your spouse create one. Doesn't have to be adapt or anything, but get a grantor trust, get it funded. So if you want to use it as a way to reflect the current law and to get assets out of your estate without making a taxable gift, you can go ahead and do it, unless the law is retroactively changed.
Jonathan, you had asked a question. I'm curious to hear Ed's answer. And I'm going to let Ed go first. I think what your question was, would you feel more comfortable with a SPAT rather than a DAPT or hybrid DAPT?
Yeah, I'll address a couple of differences there, Marty. I mean, the further away you can get to self-settled trust, it's just like Jonathan said, you're less low-hanging fruit. If under 11 USC 548E, which is a bankruptcy code section, if the creditors are on the horizon, when you file, if you, and Jonathan's, setting up a SPAT, his example, if he had creditors after him, when you're a beneficiary of a trust, you have to list that on the bankruptcy schedule. It's automatically a red or yellow flag to the bankruptcy trust. Hey, come after my money, right? I mean, on discovery, you have to say, I'm a beneficiary of this trust. That's not going to be on the question, am I a potential appointee? Because I could be a potential appointee on 1,000 trusts that I don't even know about, right? And so I think, it's a slightly different thing. We have hundreds of years of law on powers of appointment. I can go to the local law library and I can get at the restatement of property, donative transfers. And I know all the law for hundreds of years, even before the founding of the Republic, about, the powers of appointment. Trust protectors, if I put this kind of provision in a trust protector, it's the Wild West. There's 1 or 2 states that have a statute. Some states have statutes on advisors, and we don't really know whether it's a fiduciary or not. And some states have addressed it. Some states it's iffy, and we don't know judges don't know what the heck it is. They don't know where to go to look up the law on it. And you're just in the Wild West of how a judge is going to see it, in my thinking. Maybe you're more confident about how a local judge is going to view trust protectors, but I think they can look at powers of appointment a lot easier because it's been in the law a lot longer. There's a restatement that's showing us exactly what the law's been for hundreds of years. For non-fiduciary powers, it's just a lot cleaner to me. So I'm pretty for the SPAT idea, at least as an alternative to having something through a power of appointment, for sure.
You had to agree with Jonathan? You couldn't have disagreed just to make this more interesting? Let me ask you both a question. If I remember the Bankruptcy Protection Act 548E, doesn't it say self-settled trust or similar device? And we've never been able to figure out what similar device might mean. Might
Right,
this
and-
be a similar device, whatever that is?
Well, Marty, remember that 548E, whatever a similar device means, it applies only if the creditor can prove that you were attempting to hinder, delay, or defraud a creditor by the creation of this trust. And in fact, right after the Alaska Trust Act passed in 1998, I was invited to the annual meeting of the bankruptcy judges of the United States. And they said, you know, we want to be told, what about all this legislation you've gotten through in Alaska? And I explained that I wasn't really trying to allow people to harm creditors. What I was trying to do was to encourage people to do estate planning during their lifetime, but people are worried about losing all access to it. So, you know, I went to Alaska and I said, again, we're not trying to screw creditors. In fact, Alaska statutes and none of the state statutes, not any DAP state, works if what you're trying to do is to defraud or hinder a creditor. So that they were perfectly, every judge that spoke, and there were about 50 of them there, they didn't all speak, but everyone that spoke basically said, if you could establish to me that you were doing this, for example, for estate planning reasons, I wouldn't even look at the trust as possibly being one of the assets in a bankruptcy. So even though we have 548E there and we don't know what or a similar device would be other than a self-settled trust, I think you're okay if you're really doing it for good estate planning. And by the way, Marty and Ed, do you think this is a good time to do estate planning?
I'd rather wait for
Sure.
Green Book to get enacted. Yes, yes.
Yeah.
Listen,
Marty's
I
being
feel-
facetious. This is the ideal time for your clients to do it. Ideal to do it before the Green Book stuff starts coming out.
Yeah, the problem is we're a little bit like Chicken Little screaming the sky's falling, but you know what? There's no way to know what kind of backroom deals could be cut in Congress with the debt ceiling negotiations. There's no way to predict the 2024 election. If you know you can make wealth transfers today, why on earth not do it? You want to wait for Yellen to react to the requests of Elizabeth Warren and Bernie Sanders, et cetera? I mean, it surely makes sense to do it. Just two quick comments. I agree with Ed's comment that a SPAC conceptually sounds less risky perhaps than a DAPT or hybrid DAPT. But again, you know, you can't weigh the differences. You can say it sounds like it. But one of the things to keep in mind, and it amplifies what Jonathan just said, he said, if it's not a fraudulent conveyance. How do you prove after the fact that something's not a fraudulent conveyance? What we try to do before we do any kind of wealth transfers of any substance, not just a self-settled trust, but even SLATs, is to get a signed balance sheet so that we have some concept of what the wealth is that's involved, so that we hope that there's a demonstration that, like was talked about in the Levine split dollar case, that there's sufficient capital remaining with the client, that they're only planning with excess capital. I recommend to every client that they have their wealth advisor do forecasts, because the forecast not only will help them identify how this works, but it helps prove that it's not a fraudulent conveyance, because if the numbers work, how could it be a fraudulent conveyance? We get lien and judgment searches. We actually, I use an outside forensic accounting firm that does a report, because I think it looks more independent and credible than what I do. And they give a whole report on the client before transfer is made. Then we have a solvency affidavit signed. Doesn't take a lot of time, doesn't cost a lot of money. But I think if you build up the record, you're really helping the client deflect a future challenge that something may have been a fraudulent conveyance. Without hindsight, you know, without a crystal ball, rather, how do you know what something today that you do today is going to be viewed down the road? You got to document it to show that it's not. And I think that's important, whatever technique you use.
Absolutely. Well, you want to move on to the next topics here?
I think we've
Okay,
done that. 2036.
Oh,
Excitement. Go
yeah.
forward.
Can we just summarize 2036 jurisprudence in 15 minutes? Yeah, well, we'll start on some of this. I think you'll find some of the cases that we've collected, just a smattering of them, to be kind of interesting on some of these issues. But the point is 2036 no matter how you shake it out, whether it's direct or indirect access, whenever the grantor's getting funds out of a trust that they put the funds into themselves and a completed gift, there's a risk of 2036. I hear some people say, well, the only authority that that there's no estate inclusion is this 2009 PLR, or that's not necessarily true. There's some other cases that the IRS based that PLR on, right? And a Seventh Circuit case that we'll mention in the next slide. I think the first hurdle that you have to kind of come across, though, that is the real death knell, is first you have to kind of look to your state law. If you've got some kind of power of appointment holder that can appoint back to you, first check, is it, it's your state fixed the UTC statute, and how confident are you that your local judge is going to follow the comments and everything. But to kind of summarize, 2036 and the danger of it, we can just look at the quote here in the slide. It's the value of this gross estate is going to include all property. And the key language is in bold here, that the grantors retain the possession or enjoyment of. It's not necessarily the right to the income that is the problem. I mean, we can avoid having the right to income by just having discretionary interests and things like that. We avoid that particular clause, but it's the possession or enjoyment of, that's where all the nasty, juicy litigation comes from. Why do you want to go to a couple of cases, and then we can kind of get your thoughts on 2036?
Keep marching on, Ed. I think it'll be more efficient if you just cover it.
Okay, well, we already talked about the private letter rulings that are generally positive, but even the 2009 PLR that Jonathan, you got, they kind of punted on the 2036 issue and said, look, we're gonna withhold until we learn the facts of the particular issue to see whether there's a retained interest or not. The case that's fairly positive for taxpayers that you can rely on is in Yule Estate. This is a Seventh Circuit case where the settlor retained, $100 a month, and then more in the discretion of the trustee. And the court found that it was the amount necessary to produce $100 a month was right to the income that was caused 2036 inclusion, but the discretionary interest didn't necessarily cause inclusion, even though he did get a couple of payments out of the 8 years of the trust duration. And so the nutshell is the court said, well, no, not necessarily. Doesn't cause inclusion. So you do have some case law that kind of backs up the reasoning behind these private letter rulings. Jonathan, any thoughts since you got the 2009 ruling?
Yeah, I mean, first of all, if you go back to the prior page, you'll see a 1980 private letter ruling where they held that the assets would not be includable in the grantor's estate, even though the grantor was a discretionary beneficiary, because the way it construed New York law. Now, New York law developed later that the IRS's assumption that creditors couldn't attach it was probably incorrect, but that's kind of the beginning of it. Estate of German, I mentioned before, is a case where Mrs. German created this trust and she could get it in the discretion of the trustee, although the trustee had to get the permission of one of her sons, and those were adverse parties. But the court doesn't really focus on the fact that it was an adverse party. It's just that under Maryland law, her creditors could not attach the assets, even whether or not there was needed the consent of an adverse party. The 2009 private letter ruling, in fact, when this was submitted, the IRS called and said, we think this is such an obvious thing, we're going to label this just a comfort ruling, and we don't issue rulings and waste our time where it's just for comfort. And that was based upon 2004-64, the private letter ruling that's normally cited for the proposition that the grantor's payment of income tax on the income imputed to her under the grantor trust rules is not a gift. But, we argued, say, well, look, you refused to issue the ruling back in 1998, which we've also cited. I think it's 9837007, where they said, yeah, it'll be a completed gift because creditors can't get it, but we don't want to rule on the estate tax inclusion. But after they issued 2004-64, we said, you really need to issue this ruling, and they've done it. Now, by the way, there have been a couple of other states that have tried to get similar rulings, and they haven't. And the IRS just doesn't want to issue this. I mean, the head of the Estate and Gift Tax Bureau, he's no longer there, said to me one time, Jonathan, our mission is not to help taxpayers avoid tax. So I'm not going to issue rulings. And that's what he said with this earlier ruling that we had in 98, where they said, yeah, it's a completed gift, but it won't be in the estate. But the IRS finally conceded they would have to issue it and issued 2009-44002. I think the law is very clear that unless a creditor can attach it, or you have at least an implied understanding that the grantor will benefit from it in the discretion of a trustee, you're fine to go. Again, there's so much more that you can do because you don't even want to fight with the IRS. You don't want to be the low-hanging fruit. So again, do something like a SPAT, do something like make sure it's in a self-settled trust jurisdiction to make it much tougher, because the IRS doesn't like to fight hard for its money. It wants easy money. So when you do, not a full job for your client, you're making it more likely that your client's going to be the one that's going to face the attack. So I urge you, go ahead and get it in the right jurisdiction, draft it correctly, consider doing something like a SPAT, understanding I'm the one who created the DAPT in the United States, but I think that the SPAT is actually a better idea for many, many people. But do it right, get an independent fiduciary, maybe someone appointed a little later, and for goodness sake, administer the trust perfectly in accordance with its terms.
And Jonathan, I would agree with that, but to introduce these 3-4 cases here, just emphasize that the courts will bend over backwards to infer that prearranged understanding that you talked about. And that's what happened in these particular cases where, the McNichols case, the donor father gave away properties to children, but there was an oral agreement that he receive it. And then the Skinner case, the settlor did in fact receive the income, even though they didn't have the right to, but they got it anyway. And the courts kind of inferred that there must have been a prearrangement because it obviously happened. And so you didn't have as favorable facts in these particular cases. McCabe's a little bit on the different side, where he got payments, 4 payments, maybe 20 years later, not as bad as the Skinner's estate case. But I think what it does tell you when you look at some of the language of these cases, Jonathan, is that if you had a case where the settlor, and it turns out they didn't get any of the money, then you've got a really strong case, right? I mean, it's all going to depend on the facts and circumstances. If we put in bad facts, like the Skinner case, where the settlor, at some point turns on the spigot and the trustees doling out all the income every year, I think you're kind of gotten in a bad facts case similar to these cases cited here. And the hard thing is kind of, where do we give people certainty in this particular issue?
There is no certainty.
Yeah, that's the trap.
We can get them closer, but it's all kind of relative. You can't get certainty. But I think,
Right.
One of the lessons of all this is less may be more. So if a client is going to possibly need to access money in these trusts that they're structuring, let them put less money in the trust so that they can go 5 years or some number of years. There's no magic number. The longer they can go without touching the money, the better it is to make it harder to assert there was some retained interest or an implied agreement. So putting less in may be a better plan than putting more in. And I think one of the problems we're all going to face if there's no Green Book enacted before the end of 2025 is the end of 2025 is going to look like the end of 2012 and 2020 and 2021, where clients are going to, be like rushing the exits to get estate planners to shift wealth. And just like in those prior years, they're going to be trying to use up as much of their exemption as they can. And we're going to find a lot of clients that are transferring more money than they perhaps should. And that's where you're going to run into the problems that Ed and Jonathan have been talking about.
Real quick, before you get on that prior slide, the quotation from the Third Circuit, independent trustees go a long way to avoiding that prearrangement too, because I mean, obviously, corporate trustee is different than having your best friend as trustee there. And so that's kind of a quote on this case here as well on this slide. Just remember that the courts are just going to be skeptical, especially when family member or friends are a trustee. They're going to lean towards inferring a prearrangement of some kind. And so just a couple of things to consider in that regard too.
And the family and friends are never, I shouldn't say never, but they'll rarely keep the kind of paperwork that an institution will. If somebody comes to your bank and asks for a distribution of a trust, they have a distribution committee that's going to convene independently at their appointed time and evaluate the facts and make a decision and document it. I mean, that's what you want. And if you have to have a client name an individual, because that's what they insist on doing, they should at least then come back every year before any transactions are done and meet with the professional advisors and document things like an institution would. But that's rare to happen. And I think that's as much of a concern as the optics of it is the administration of it. I think we've all kind of said that a few times. Any last comments, Ed, or we can go on?
I will move to the next comment. The Paxson case kind of said the same thing, that they'll move to infer if they see bad facts, the pre-arrangement, I think.
But Ed, can't I just borrow the money? Why do I have to worry about getting a distribution? Can't I just borrow the money?
Yeah, I had an attorney tell a client this once, and I had to kind of address this. Well, you can kind of, but don't go too far in promising that. I've heard that where, yes, a SLAT can make loans back to the grantor, right? I mean, just like, and of course, one of the most popular strategies out there is an installment sale to a grantor trust, right? That's essentially a loan, right? And so if you have a reasonable bona fide loan, yes, that's okay, but just don't overpromise that you can start lending the entire corpus of the trust whenever the grantor needs it, because the problem is if they really, really do need it, they're not very financially viable probably, and then it's a breach of duty, and that's going to cause more problems. But anything that's arm's length, I think, is probably okay. Smaller is better. Be the low-hanging fruit, as Jonathan said, and make large loans, because it's going to look just like a distribution. Unless you really paper and collect on the interest and et cetera, just like a real loan would.
What about if I name somebody? What if I name Jonathan in my trust in a non-fiduciary capacity to be able to loan me money without adequate consideration? Now that's a standard power put in to make a trust a grantor trust. It's also a great way to provide access to borrow money if the trustee feels they can't make a loan in accordance with the general terms or investment standards of the trust. What if that Jonathan as a non-fiduciary loans me $100,000 from my trust?
Yeah,
I don't like the sound of that.
Yeah. Yeah, just try not to get too cute. The more arm's length, and not even now we do loans at AFR, but I mean, you could even just go commercial rates too if you want to be even more conservative.
I was going to wait. Jonathan, I have to get a comment in. Ed told me not to be too cute. I could never be as cute as the two of you. Okay.
Yeah, right. Let me point out something that may not be obvious. Section 7872 provides a safe harbor when you loan money at the applicable federal rate. But that doesn't apply, for example, necessarily from a loan from a trust to the grantor or even to a beneficiary, because 7872 safe harbor only applies between employers and employees and where the loan is in the nature of a gift. So before you go ahead and say, well, that's what I'm going to do, you need to consider whether or not it's really going to fall under that exception under 7872. I don't think it applies to a trust.
Not in this context, I would think. And I think the issue becomes not letting individuals overdo it. That's why I like an institutional trustee involved. Can you loan money every year to the settlor? Will that work? What if the amount loaned is exceedingly similar to the amount of income the trust earned? It doesn't look good either.
Ouch.
So,
yeah.
Yeah. So you want to be careful. I mean, we're going to very briefly mention tax reimbursement clause, but the worst tax reimbursement clause administration I've ever seen. I had a new client when I started asking questions and getting information. Her accountant was having the trust pay her quarterly estimated tax every year for years because it says it can reimburse her for taxes. It's not what it said. Yeah, bad.
Okay.
You gotta be very judicious and practical with all this. But again, it goes back to, if we can't meet with the clients and the people involved once a year, we're never going to know that this goes on. I don't think I've ever seen a tax reimbursement clause, and we're going to come to that in a second, where they've actually had a calculation by an independent accountant of what the reimbursement amount is. They've just been guessing. You can't do that either. You really need to be careful with all this stuff. Ed, why don't we're getting near the end, but I think divorce is important to talk about, especially the floating spouse. So.
Yeah, and we'll go through this part quick because I do want to hit reimbursements, but think twice and maybe 3 times before using the floating spouse idea in a SLAT. It sounds great when you first look at it, but when you look at what the ramifications might be in a divorce situation, they may not be as favorable as clients think. First of all, some state statutes that might kill the backdoor SLAT access in Florida. You've got this protection under their new statute, but if you have a floating spouse, you don't get that protection because the spouse has to have a lifetime interest that can't be divested to come under that particular statute. Obviously, just worth reminder, you can't have any kind of removal of a spouse if you're trying to do a marital trust. Marital trust, you can't, remove the spouse on divorce, just a reminder there. But it doesn't necessarily cause a problem, I don't think, from an estate inclusion standpoint. If I set up a completed gift non-marital trust, I can have the spouse be divested upon divorce, and I don't think that's necessarily an estate tax problem. It's a independent action that's, even though I may have filed the divorce, the IRS has ruled in other contexts that doesn't necessarily cause 2036 problem, but I think it might backfire in some cases, depending on the domestic relations court at issue in your particular state and jurisdiction. And that we've got a couple of examples on the next slide, to go over. I wrote a couple of articles about some cases we had in Ohio where you kind of had a little bit of a backfiring where and this is the example here where the husband gives $10 million SLATs. In the particular case at bar was in 2012 and a $5 million instead of $10 million, but it may be considered separate property of the donee spouse upon divorce. And so if it's not reciprocal, in other words, it's only one spouse gifting into the SLAT. Remember that, the donee spouse might have the SLAT interest plus half of your other assets. If the DR court's not going to count that equitable interest in trust as part of the donee spouse's 50% property. So just keep in mind, it's going to vary state by state. I don't have too much more to say about it, Marty, because these kind of clauses and the impact in a divorce could vary considerably from jurisdiction to jurisdiction.
Also keep in mind that if you create a trust for your spouse, it's a grantor trust with respect to you. Now that, if you're hearing it for the first time, it sounds crazy. Wait a minute. I create a trust for my wife and I'm going to be tagged with the income? Yes, that's the way the grantor trust rule. And unfortunately, it also means that if you get divorced and your spouse still remains a beneficiary, you're going to continue to be taxed on the income from that trust. Just imagine how terrible. You've created this big trust for your spouse. She runs off with Ed Morrow because he's so much more handsome and clever than you were, and yet she's still going to get the income or be eligible for it, and yet you're going to have to pay the income tax. Unacceptable. So one of the things you want to do in your SLATs is to put in a provision that the spouse is out in the event of a divorce or separation, and also consider putting in something that the spouse can only get distributions if there's a separation or a divorce with the consent of an adverse party within the meaning of section 672C. And that should protect you from being continually hit with the income tax on the trust income if your spouse leaves you. Very, very important. Don't forget it.
And you also have to be mindful of just the whole issues of representation, which is a different discussion and not for today's webinar. When you're representing a married couple, where can you go with this? What issues do you have? It gets quite thorny. Let's go on so we can wrap up because we're close to the end of time and our slides. Ed, why don't you just comment quickly on ways to destroy SLAT benefits, and then we'll do it quickly on tax reimbursements, which we've already talked about
Yeah,
a bit. And then we'll wrap up.
and you've probably talked about this on other seminars, I'm sure, Marty. You know, you do want to make sure that you don't inadvertently fund a SLAT from community property or from a joint account or from the donee spouse's assets. That's kind of a gimme. And as you pointed out, Marty, sometimes you know, practitioners will do the trust, and you know, years later, without calling you, they put more money into the trust without wanting to save a few hundred $1,000 on a new console. You know, they don't listen to you. So make sure you put in your agreement, hey, when you fund a new trust, come back to me for advice on it, or tell them what not to do, I guess. Of course, in the community property state, you've got to do, you know, transmutation agreements for community property to separate it out. We won't go into reciprocal trust right now, but that's another thing to avoid, of course. Same day immediate transfers, you know, like in, you know, a lot of, you know, our clients, they have joint accounts. That's where they have a lot of their assets. Joint, you know, not just joint trust, but, you know, just separate joint brokerage account. There are a couple of cases. We cited one, a Smaldino case, which was more recent, and a little bit older, the Betty Brown case. You know, how much time, if I have a joint account and I take the money, you know, $100,000 out or whatever, $1 million, doesn't matter, out of the joint account, I put it in the donor spouse's name, then I fund a SLAT with that money. You know, is that a step transaction? You know, how much time is, don't do it the same day. Just try to keep as much, don't be the low hanging fruit, as Jonathan said, put some time in between. Don't be like the Betty Brown case or Smaldino case. You know, put some time in between so that there's a meaningful economic difference, you know, justified by the space of time between the two transfers.
And have, if you can, independent economic events of significance. So
Right.
if you have a joint account, you put, you know, a chunk of wealth in the wife's name, let her do a new investment policy statement, maybe move to a new brokerage firm or get a different advisor, do a new asset allocation, mix it up, get a distribution. If it's an LLC, get a distribution, do a new operating agreement. You want to have significant events in addition, if you can, to time. And there is no magic number on time.
No.
Ed, why don't you just cover tax reimbursements quickly, and then I think we're done.
Well, these are, you
Close
know,
to
we
them.
have, yeah, we have clarity about how, you know, an income tax reimbursement clause in a grantor trust is treated for federal transfer tax purposes. But remember, in Revenue Ruling 2004-64, they said, okay, if you avoid the mandatory reimbursement, you know, and you avoid a prearrangement, we're not going to, it's not going to cause a state inclusion just because the trustee has the discretion to reimburse the grantor for the income taxes paid, as long as it doesn't cause, you know, creditor access under state law. And I think that's a part of that revenue ruling that might be missed easily by a lot of practitioners. Some states will have express, you know, statutes that will allow a trustee to reimburse the grantor, even if it's not in the document. And those states are listed here at the bottom of this slide. And on the next slide, I think we have states that have clarified, and usually these are under UTC 505, the same section we talked about earlier, states that have clarified that this doesn't cause self-settled trust access. Because remember, if you're giving the trustee the discretion to make a distribution back to the settlor, it kind of smells just like a self-settled trust, doesn't it? And so I think you'd want to, if you're going to have a trust reimbursement clause, hopefully your state has clarified under either UTC 505 or otherwise that this doesn't cause self-settled trust access.
You want to make some concluding comments, Jonathan? I don't hear you.
I want you to do it, Marty. You're prettier than Ed and I are, so why don't you finish up?
Bats are the way to go, everyone. How about that? So what hopefully we've covered is to really give some insight and more detailed analysis of this concept of a backdoor SLAT, which is just ways to provide access. Clearly, with 2020, the end of 2025, before 2026, lots of clients are going to want to transfer wealth. With the huge inflation adjustments to the exemption, lots of clients are going to want to transfer wealth. And if anyone takes the Green Book seriously, which we certainly feel they need to, because you don't know what might be enacted in Washington or the letter Jonathan mentioned that several prominent senators, congressmen have sent to Janet Yellen, you know, change could happen. So it's certainly better to get the planning done, get it while you can. And in doing so, it's important to plan properly how the clients will get access to these trusts without causing estate inclusion or reach by creditors. We've gone through lots of different optional ways you can provide access, whether it's a tax reimbursement clause, a loan provision, a SPAT provision, a hybrid DAP provision, and so on. And there's certainly ways that you can enhance the likelihood of that type of plan succeeding. I think we've all encouraged you as advisors to recommend your clients use DAP jurisdictions and institutional trustees. Where there's a hesitancy on the client to do it, I think we've given you a lot of good reasoning that you can present to your clients to encourage them to do what we feel is better planning like that. If you're not in a DAP jurisdiction with an institutional trustee, Ed has gone through and given you lots of citations for different states about what you need to look for in state law to make sure you're not running afoul of a problem. But I think some overarching concepts within, you know, within that discussion is that you want to make sure you document that it's not a fraudulent conveyance on the front end, because if it's later proved to be, how do you deflect that? And any type of step that's deemed to be a fraudulent conveyance is going to be unwound. And on the back end, once the trust and the plan is set up, and considering all the different ideas that we talked about, and we didn't go into great detail about plan administration, trust administration, but it's vital. You know, using Jonathan's off-use phrase, you don't want to be the low-hanging fruit. Why should the IRS expend resources on a highly technical 2036 argument if you've just completely violated the terms of the trust or the plan, like in Smaldino or Sorensen? Ed, any last words to wrap up?
No, I think you wrapped it up pretty succinctly, Marty. Thanks to Interactive and you guys for having me on as a guest.
Always a pleasure. Thank you, everyone, for joining us. Jonathan and Ed, thank you for the help. Take care,
Thanks
everybody.
everyone for being part of this. I hope it was enjoyable and informative, and I hope it'll help your practice.
Take care, everybody.